If you've watched any of my videos, you will see that I talk about trademarks extensively. In fact, I dedicated this whole channel to trademarks because I think they are that important and that every business should consider registering trademarks for the most important pieces of their brand identity. And I practice what I preach. So I registered a trademark for my law firm, and I'm going to take you through my personal success story with a trademark application so you can learn what to do when you consider applying for yours. Hey friends, welcome back to my YouTube channel. I'm so happy you're joining me today. Like, really happy. I'm Faith Mitton, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you will find tons of free, practical, and easy to understand insight about trademarks to help you learn how to better protect yourself and to stay on the right side of the law. Like I said a few seconds ago, I'm ecstatic that you are joining me today because I'm going to be walking you through my own successful trademark application because I want to show you what a good trademark application looks like. First, let's start with what I chose to trademark. Trademark selection is the most important part of the trademark application journey because it can make or break your success. Before you do anything, you need to determine whether what you want to trademark is worthy of trademark protection. So let's back up for a second. What is a trademark? A trademark is a type of intellectual property that protects a business's brand identity. The things most commonly registered as trademarks include names, taglines, slogans, and logos. But the trademark universe is humongous, and there are many other types of non-traditional trademarks for things like building designs and product packaging and colors and sounds and scents and much more. But the point of a trademark is that it functions as a source identifier. It tells people who the source of a product or a service is so they can know who to buy stuff from. But not everything can or even should be trademarked. There are strong trademarks and there are weak trademarks. In another video, I've gone into a lot more detail about how to rank trademarks in terms of strength, which I will tag here and link to in the description. The point is that there are different categories for strong trademarks versus weak trademarks. And when you're deciding whether to apply for a trademark, it makes sense to apply for a trademark if it falls into one of the strong categories. And if it falls into the weak category, you might want to consider rebranding to get yourself into the stronger category. But in that video, I talk about fanciful, arbitrary, and suggestive trademarks as examples of strong trademarks. Fanciful trademarks are made-up words with no dictionary definition whatsoever. Arbitrary trademarks have no logical connection to the products and services they're used to promote, and suggestive trademarks imply a connection to their products and services. That's what I'm going to say here. If you want to learn more about trademark strength, be sure to check out that video that I mentioned earlier. But back to my story, because I think that my trademark fell into the strong category and the USPTO agreed with me. But as some background, my law firm's name is Mitton Law Firm PLLC. That's just my last name combined with a descriptive phrase. That's a terrible trademark because it is not unique or creative or clever in any way. So instead of opting to register a trademark for my law firm name, I opted to register a trademark for its tagline, which I think is the most unique and compelling and clever portion of my firm's brand identity. And the tagline is making sure no one gets their mitts on your IP. This is a clever trademark because it involves wordplay and figurative language, which requires people to do some thinking to figure out what the trademark means. In terms of wordplay, I use mitts on, which is a play on my last name, Mitton, and mitts is another word for hands. So another way that you could interpret my trademark is making sure no one gets their hands on your IP. But trademarks are intellectual property. They are intangible assets. So it's not like someone could literally place their hands on your IP to steal it. Trademark infringement doesn't involve stealing your trademark registration certificate. There's no physical component to it. It's all intangible. So when I say making sure no one gets their mitts on your IP, I'm addressing theft of your IP in a figurative sense and preventing that theft is what I do as an IP attorney. So this combination of wordplay and figurative language makes for a really unique trademark that falls into the suggestive category I mentioned earlier. It implies what the benefit of hiring my firm is rather than spelling it out very obviously by saying, hey, let me register your trademark for you. Pro tip, when you are choosing something that you want to register a trademark for, choose something that is memorable because it is clever and unique, not because it is descriptive and obvious. Trademarks that are descriptive and obvious are really hard to protect and they struggle through the trademark application process. And you know me, I always have resources. There's another video on this channel about descriptive trademarks, which I will tag here and link to in the description if you want to learn more about this topic. But moving on to the next portion of my success story. The thing that I did after I chose a clever and unique trademark that was suggestive is to clear it and check whether there are any other trademarks that could have posed a problem for mine. And I did this by doing a thorough trademark clearance search. The topic of trademark clearance searches is a big one, and I won't go into too much detail here. I'll make another video about that. But for now, what I will say is that a trademark clearance search's purpose is to discover whether there are any other trademarks out there that could block the approval of your trademark application or otherwise cause problems and headaches for you. And by a trademark clearance search, I'm not talking about Googling the trademark that you want or looking at the USPTO database. A thorough trademark clearance search goes beyond that and is usually performed by a knowledgeable trademark attorney. Because what we're looking for in these kinds of searches is confusing similarity. A trademark does not need to be identical to yours in order to pose a problem. It just needs to look like yours, sound like yours, or have a similar meaning, and be used in connection with products or services that are related to yours. And you may be shocked to find out what's considered to be confusingly similar. But again, back to my story, because I am a trademark attorney, I know how to do a proper, thorough trademark clearance search, and I did one for my tagline. Now, because my tagline is pretty clever and unique, I didn't find any other problematic trademarks that could be confusingly similar with mine. And this is the key. The first two things that I talked about are 90% of the work when it comes to trademark applications. If you do a good job on these two things, choosing a unique trademark and then doing a thorough trademark clearance search to find out if it's available for you to use and register, then everything else is a piece of cake. But now let's talk about the actual trademark application, the filing itself, because there are 4 things that every successful trademark application must get right. And I got all 4 things right when I applied. These 4 things are filing basis, specimen, class, and description. Let's talk about each of them, looking through the lens of my own trademark application. First up, filing basis. When you apply to register your trademark with the USPTO, you will need to tell the agency whether you are applying for the trademark because you are already using it or because you intend to use it at some point in the future. This concept of trademark use is important because in the US, in order to get trademark rights, you must be using the trademark. And by using the trademark, I mean selling products under it or providing services under it. Trademark use is a whole nother big topic, which I will create another video about at some point. But you do not need to be using your trademark in order to apply to register it with the USPTO. So as a US-based business owner, you will need to tell the USPTO, like I mentioned earlier, whether you are applying for the trademark because you are already using it or because you intend to use it in the future. This is the concept of a filing basis. If you are using your trademark, you will apply for it on an in-use filing basis. And if you are not yet using it and you haven't publicly launched your brand yet, you would apply for your trademark on an intent to use filing basis. For non-US based business owners, there are other filing bases, but I won't cover that here. Stepping back to my trademark application, because I was using my tagline at the time when I applied for my trademark registration, I filed on an in-use filing basis or a 1A filing basis. And with this filing basis, you have to submit a specimen for your trademark at the time of the application. Submitting a proper specimen is the second thing that every successful trademark application must get right. A specimen is just another word for proof of use for your trademark. There are many, many things that you can use as a specimen, but screenshots of websites are most commonly used because they're just the easiest things to collect. But in order for something to function as a specimen and to be accepted by the USPTO as a specimen, it has to meet certain requirements. The trademark must be clearly visible and prominently featured. And the specimen needs to show the trademark used in close proximity to whatever products or services are listed in the trademark application. So taking a look at my specimen, you can see that I used a screenshot of my website where my law firm's tagline was prominently displayed in close proximity to a description of the types of services that I offer. So when you are choosing a specimen for your trademark application, you will want to make sure that the trademark that you applied for is clearly visible, that it matches your application exactly, and that it is in close proximity to the products and services listed in your application. Moving on to the third thing that every successful trademark application does right, classification. You must apply for a trademark in at least one class. Classes are huge categories of products and services that the USPTO uses to organize all the trademarks it's responsible for. You can definitely apply to register your trademark in more than one class if that applies to your situation, but the minimum is one class. If you choose the wrong class, that can be a reason for the USPTO to reject your trademark application. So you want to do some investigation before you apply to figure out what class or classes you should be applying in. The point being that when you submit a trademark application, it does not cover any and everything. The registration of your trademark, if approved, will be limited largely only to the things that you list in your trademark application. So don't think that because you file a trademark application for clothing, that it's going to protect you for automotive parts. Those are in completely different classes. And so if you need broader protection beyond a single class, you have to apply in more than one class. Again, this is why careful evaluation of your brand and business should be conducted before you file your trademark application to figure out what class or classes you need to apply in, because you cannot add classes after you apply. It's a one and done deal. Whatever you submit is what you're stuck with. So because I am a legal professional, my services fall in class 45. And so that's the class I chose to apply to register my trademark in. But because classes are so broad, there are only 45 of them, but there are more than 45 ways of doing business. They cover a ridiculous number of things. So in addition to choosing a class, you must also create a description of your products and services. This is the fourth thing that every successful trademark application must get right. The purpose of a description, like I said before, is to pinpoint exactly within the class what products or services that you provide under your trademark. Good descriptions are simultaneously broad and narrow. Broad enough to allow you the flexibility to pivot without losing your trademark protection or needing to file a whole bunch of new applications, but narrow enough so that it isn't considered overbroad so the USPTO doesn't reject your application. Drafting descriptions this way, quite honestly, is a skill set. It's an art form that takes years of practice to develop, and a knowledgeable trademark attorney can help you with this kind of description. And as an example of what I mean, let's look at my description. It's kind of on the long side, but you can see that I included both general language as well as specific language. General language being just legal services, and more specific language such as legal services relating to the registration of trademarks. But because I did all these things, I chose a very clever and unique trademark. I did a thorough clearance search for the trademark before I filed the application. And then my filing basis, specimen, class, and description were all in order. My trademark application got approved pretty quickly without any pushback from the USPTO or another brand owner. And that is the goal when you apply for your trademarks. You want it to be smooth sailing from the filing all the way to approval. But that is not the guaranteed path. There are many potential hiccups that you can encounter on your trademark application journey. This is why it is useful to have a trademark attorney represent you in the process, because there are lots of traps for the unwary. The attorney's first job is to help you avoid any bumps in the road, but some bumps are unavoidable. And so the attorney's job in those situations is to help you navigate around those bumps and hopefully steer you towards approval of your trademark application. What you don't want to do is rely on a video like this because it's just a summary of some things for you to consider as a trademark applicant. And like all summaries, it leaves a lot of things unsaid. So your best bet is to seek legal advice and representation from a knowledgeable trademark attorney for your specific situation. And that's a wrap. You've seen my trademark success story, and now you know what is possible and what you should do for your own trademark application. If you enjoyed this video, please give it a thumbs up. Be sure to subscribe to the channel for more trademark content and to turn on notifications so you never miss when I post a new video. If you've got thoughts or questions to share, I invite you to put those in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.